So I wanted to talk about a few of the most popular reasons why people will put off getting a will or just not get a will altogether. So the first is that I'm too young to write a will. Well, that's just not true. If you're 18, you can write a will, and most times you're going to have your own assets at that point. Now, I did an earlier video about the three thresholds for when you really need a will. One is that if you have a house, if you're married or have children, and if you have $20,000 in assets. So those are pretty much the bare minimum for a will. Obviously, if you're 18, you may not have those. But there are many 20 and 30 and 40-somethings that don't have wills because they think they're too young. Well, tomorrow is really guaranteed to no one. So that kind of goes to the invincibility fallacy, and that everybody thinks that there's going to be another day. Well, a lot of people die unexpectedly and well before their time, so to speak. So that's unfortunate. That's a reason, but I totally understand, why people may think that. They just need to get past that. Some people just don't want to talk about dying. So estate planning obviously revolves around planning for your exit strategy. Whether that's going to be through disability or death, and that can be a difficult discussion to have. But it's worse to not have it at all and have your family try to pick up the pieces after you're gone. After you can no longer speak for yourself. So while it may be an uncomfortable topic, it's one that needs to happen. It's kind of like the birds and the bees or those sorts of things. Not everything that's uncomfortable needs to be avoided. There's also a jinx surrounding, or this fallacy of a jinx surrounding estate planning, that if I talk about estate planning or I get my will in order, then I'm going to die. Well, that's obviously not the case, or else there'd be a lot more dead people in the United States. So there's also a belief that assets will just automatically pass to the person or to the people that need them or that should have them. Well, that's not the case either, because there are default rules that are going to control if you don't have a will, and those default rules don't take into consideration anything about you. It's pretty much what the legislature thinks the average person would want to happen with their estate, and frankly, the rules are stupid. They don't make any sense. And unfortunately, people's estates end up being dictated by the default rules because they don't understand what the default rules are. And that kind of goes to another one, is the lack of education. People don't understand what happens when you don't have a will. They don't understand what the default rules are. So for instance, if you're married and you have parents that are still living, your spouse doesn't get everything, and that's stupid. If you have living parents, your parents are going to have a little less than a half of your estate. They're going to take a little less than half of your estate. So the first $60,000 is going to go to your spouse, and half the remainder, and then half of your real estate. The other half of everything is going to go to your parents, or the survivor of them if you just have one parent. And obviously that's North Carolina. The other states may have different default rules, but most people wouldn't want that to happen. And that's kind of a driving force for most people when they realize that, their spouse or their kids aren't going to get everything. Then they want to take their own rules and put them into place rather than relying on the default rules. Some people think that drafting a will is expensive. Well, it's actually one of the cheaper forms of legal planning, and you kind of have to balance values. So you're going to have expense now and expense after you die. The expense now is going to be shouldered by you, and it's going to come out of your budget. You can plan for it. The expense after you die is going to be much, much more, and it's going to be shouldered by your family, either through your estate or individually if there's nothing left in your estate. So cost is pretty relative here, but it's still only going to be between probably $100 and maybe $500 or $600, depending on the attorney, to get your will in order. So to give you a snapshot of what the expense might look like on the back end, is you're looking at probate fees, you're looking at attorney's fees, and those sorts of things. And the attorney's fees are more likely if you don't have a plan in place, because then your family may need help sorting out what the default rules are. So having your own plan through a will is worth its weight in gold. Some other people are reluctant to discuss personal matters with lawyers. And that's unfortunate because this is why the attorney-client privilege exists, to make sure that people can have a frank and open discussion with their lawyer and not have to worry about that information, getting out. So, especially in a practice area like estate planning, that's a very personal and sensitive practice area, and I take that responsibility very seriously. So, what my clients tell me is essentially in a vault. No one else will ever know about it, and sometimes my clients share very personal details about themselves and their families, especially when we're talking about planning for either the disinheritance of a child or a family member, or certain unfortunate circumstances that have occurred in their history. So that attorney-client privilege, that relationship, should foster disclosure rather than preclude it. And then, the last one I'm going to talk about is the belief that only rich people need wills, that only wealthy people need wills, and that's, I guess, going to encompass people who are probably in the upper middle class, for that definition. Again, going back to those three, thresholds, those three pillars of when a will should be in place, doesn't take much to get to those. It doesn't take that many assets. $20,000 in personal property, a house, or a family. You don't have to be rich to have any of those three things. And I would say probably a lot of Americans have any or all three of those things. So, and frankly, people who are high net worth, they're really wealthy, are going far and above, over and above just the will. They're going to be using trust-based planning. They're going to be using tax planning, and much more thorough and robust planning than just a will. So the will is more meant for the everyman, the average American. If you meet one of those three threshold requirements. So stop procrastinating, get it done. If you have any questions, let me know.